Good morning, everybody. Thank you all for joining us. We're gonna slow roll our start here until everybody makes it in from the waiting room. And got a couple people hung up in there, but I'm gonna go ahead and get us started. Well, thank you all for joining us. It's been a few weeks since I have been with you guys here, so I'm glad to be back. I was sick last week and Ken had to take over for me because I had no voice, which for anybody who knows me in real life or participates in these Q&As was a real challenge for me. I think, as always, we're going to start with our Zoom housekeeping items. I'm going to remind everybody to please stay muted during the Q&A. Unless you want to unmute yourself to ask a question, you are welcome to do that if you would like to, but otherwise, please stay muted just so we can minimize background noise and make it easy for everybody to hear. If you're not sure where your Zoom toolbar is, that's usually at the bottom of your screen. That's where you can find your mute and unmute buttons, as well as your start and stop video buttons. You can stay on video if you would like. You're welcome to turn your video off and work in the background, or I don't know, climb on the Stairmaster while you're listening to us, whatever folks need to do. So that's at your discretion. We, every week, remind you guys that we are here to give general legal information and not specific legal advice for your community. And so as you all email us your questions throughout the week, sometimes you'll get an email back from Chelsea saying, sorry, this is way too specific. We can't cover it in our Q&A. First of all, don't shoot the messenger. Chelsea is not the one that makes those judgment calls. I'm the one that makes those judgment calls when the questions are too specific. So if you want to be mad about it, you can be mad at me. And second of all, we do try when we can, if it's a sort of a broadly helpful topic, we try to cover the topic generally when we can, even if we're not able to answer your specific question. Speaking of questions and how to submit them both during the Q&A and throughout the week, I put a message into the chat a little bit ago, and it gives you the email address to which you can send your questions in advance of each week's Q&A. It's info@condolaw.net. Please get us your questions by 4 p.m. on Monday so that we have a little time to prep, excuse me, our answers for the Wednesday morning Q&A. And the message that I put into the chat does also have the link to our YouTube channel. Most of the time, we have the video from each week's Q&A up on the YouTube channel within about 24 hours of the Q&A on Wednesday mornings. And the YouTube channel is also a great resource if you want to research a particular subject that you know we've probably talked about a lot. And the way that you do that is you click on the link that takes you to our YouTube channel, and not in the YouTube search bar at the top of the page, but within our channel, there's a channel-specific search bar, and you can use that to search terms on the subject that you want to look into. If it's insurance related, you can search for insurance, you can search for special assessment, you can search for reserve studies, etc. As you might imagine, if you search for something like the CTA, you're going to find a lot of recent videos talking about that, because we've been talking about it a lot, and we'll talk about it a little bit today too, just in a few moments. We also want to tell you that we only have like 6 questions that were sent to us in advance today. So if you have a question and you've been on the fence about whether you want to put it into the chat today, please go ahead and do that, because we are likely to have time to get to at least a handful of questions from the chat during our Q&A today. I am going to put a link into the chat in just a second here for the Washington State Community Associations Institute Legislative Action Committee Monday morning minute emails. That's a mouthful, but that's the link that I just put into the chat. Our Legislative Action Committee is gearing up for what is going to be a very busy legislative session starting on January 13th. And the Monday morning minute is a short email that goes out once a week on Monday mornings. It's written by the chair of our Legislative Action Committee, and it keeps people in our community informed about what is happening on the legislative front. And sometimes there are calls to action in that email. So if you are interested in having an understanding of what is happening legislatively when it comes to community associations, and making a difference in some of those things when we do the call to action, whether it be to contact your legislator or even potentially to testify at a hearing, with regard to some of that legislation, please consider signing up for the Monday Morning Minute. If you signed up in years past, you have to sign up again. The email list, for some reason, just gets cleared every year. So you have to re-sign up each legislative session to ensure that you receive those emails. I think last week we announced to everybody for the first time that our fee schedule is changing on January 1st of 2025. We've added a number of flat fees and some of our rates are going up. And so for any work for flat fee items that's ordered in 2024 before the end of this month, we're going to be honoring the 2024 rates even if the work isn't completed until sometime in 2025. So for example, if you've been considering a restatement or an amendment or some other big ticket item like that, you might want to consider getting that order into us before the end of the month so that we will be able to do them at the lower 2024 rate instead of the higher 2025 rate. So if you have questions about that, you can email us. We also want to remind you that we are not doing the Q&A on Wednesday, December 25th or Wednesday, January 1st. Both of those are federal holidays. And whether or not you celebrate those holidays, our office is going to be closed on those days. And so we will have 2 weeks off in a row, which I don't know the last time that we did that. So hopefully everybody will enjoy the break and we'll be back here, of course, on January 8th going forward. I think that covers all of the announcements, unless, Tima, can you think of anything that I might have missed or that I should bring up?
I don't see anything that you missed, Valerie.
Okay, well, why don't you go ahead and take us away with our first question then?
Okay, our first question today is the fact that a Texas court ruled that the CTA could not be enforced was brought up to me today. And I would like to know if we still need to report everything by December 31st. So the short answer to this question is that the ruling was with a Texas court, but it does apply to as an injunction nationwide. However, it's a preliminary injunction. And what that means is it only temporarily suspends the requirement. So from a practical standpoint, the risk of penalty is less for non-compliance, but from the legal perspective, our guidance to our clients is that the lowest risk option is to comply and to go forward with, as planned, with the reporting requirement for a couple of reasons. One, we don't know when the injunction will be lifted, and we don't know what the penalty is when the injunction is lifted, what that will mean for our clients. So, the short answer is yes, you're correct. There is no penalty right now for non-compliance, but again, to repeat, the best low risk option, which is what we recommend, is to move forward with the compliance requirement. Valerie, did you have any further comment on that?
Yeah, I think the only distinction I would add is, and this is probably only something that matters to lawyers maybe, but the injunction does not invalidate the reporting requirements. Doesn't say that the reporting requirements are unconstitutional. All it does is temporarily suspend the Treasury Department's right to enforce the requirements. So I think that's an important distinction. And otherwise, I think you covered it thoroughly, and that's all we need to say on that.
We have a couple other CTA related questions in the chat. Do you want to cover them now or do you want to save them till the end?
I think I'll save them till the end. I want to make sure that we get to the questions that we've had submitted in advance. So I'm going to move on to our next question, which is, both HOA and master meetings are designated as open meetings in our condo bylaws. Does this indicate attending owners have the right to comment on items discussed, or do they only have the right to observe the board's discussion? As a related question, do discussion items need to be presented to the owners prior to the HOA/master meeting? If owners/members are not provided advance notice of discussion items, is the board able to vote on these items? So I'm going to say as a starting point that we're not really sure what you mean by HOA meetings versus master meetings. Is the HOA the master association and the condo is the sub-association? And I'm not really sure that it matters so much for the purpose of the question. And so I'm going to start by covering just your questions when it comes to board meetings. And I'm going to cover this broadly enough that regardless of what type of association you're in, you should get the answer to this question. If your association is governed by WUCIOA, that statute does require boards to allow owners to comment at board meetings. And if you're curious about the statute that requires that, it's RCW 64.90.445 subsection 2E. And I'm going to go ahead and copy and paste that citation, excuse me, into the chat. So that section of WUCIOA says that owners must be given a meaningful opportunity to comment on association business at board meetings. It also says that the board can expel or prohibit attendance by any person who, after being warned by the chair of the meeting, disrupts the meeting. And I think it's important to understand that regardless of what type of community you're in, and regardless of what owner or open meeting means for your community, open meeting does not mean that owners get to just randomly interrupt and disrupt the meeting, that owners get to try to wrest control of the meeting away from the chair. Owner comment means that they are able to comment in a orderly manner as determined by the chair of the meeting. So I'm going to keep going on to answer this question, but I'll come back to this a little bit later. If the association that is holding the board meetings is not a WUCIOA community, if it's an HOA Act community, it does have an open board meeting requirement, but no owner comment requirement. If it's a condo association, there's no open board meeting requirement in the statute, but your documents might have an open board meeting requirement. And for all three types of non-WUCIOA communities, whether your open meeting requirement is under the HOA Act or if it's just in your condo documents, none of those mean that owners have the right to comment during the board meeting unless the governing documents say otherwise. I will offer that some clients, a lot of our clients, that don't have an owner comment requirement in their documents or in their statute choose to provide for that anyways by holding a brief, owner forum either at the beginning of the board meeting or at the end of the board meeting. Some of them just offer that anyways, even though it's not required. And again, owner comment rights do not mean that owners get to interrupt the board while the board is discussing and voting on agenda items. And an association can certainly adopt reasonable rules governing owner comment at board meetings and what that should look like. On the topic of providing the agenda in advance, WUCIOA does require that the agenda for each board meeting be provided with the notice of the board meeting, which has to be sent at least 14 days before the meeting. So you can either send out individual board meeting notices for no less than 14 and no more than 50 days before each board meeting, in which case you have to also include a copy of the agenda for each specific board meeting. Or you can adopt an annual board meeting schedule. For example, I'm just going to randomly throw out the second Tuesday of the month at the Cabana at 7 o'clock, okay? And if you do that, you can provide an annual notice with that board meeting schedule a year in advance, and then you can provide a standard agenda with that annual schedule, but you don't then also have to, let me caveat here. We don't think, when we read the meetings statute as a whole, we don't think the legislature intended to also require you to then send out a specific agenda 14 days in advance of each board meeting. We do think that part of how you comply with what was the clear legislative intent, which is to keep owners as informed as possible with what's going on in the board meetings, make the agenda available to the owners, along with any other board members, any other materials the board members rely on during the board meeting, which is also something that's required under WUCIOA, keeping those, making those materials available to the owners at the meeting. I think it's worth saying, as I did just a second ago, that the legislature did not make this entirely clear, meaning the question of if you publish your board meeting schedule a year in advance, it's not 100% clear from the statute whether it also requires you to then mail the specific agenda 14 days before each meeting. And I think there's a reasonableness component here too, which goes to your question of, can the board vote on anything that's not already on the agenda, right? We're trying to give meaning to the statute and to the clear legislative intent as we understand it, while also allowing associations to function and do business in a practical and efficient manner. So whether an item has to be on the agenda distributed in advance of a meeting might depend on your specific documents and the subject matter of the vote, right? I do think it's impractical to assume that every single issue the board ever needs to vote on has to be known in advance or can't be known in advance, and therefore can be added to the agenda. But I think, again, going back to the legislative intent, which is very clearly to keep owners informed about what business the board intends to do at its meetings, if you keep that intent in mind as you approach your notifications to owners, your distribution of the agenda, et cetera, that should be your touchstone. So I want to briefly touch on some of these questions when it comes to association meetings, even though I'm not really sure the question was asking about them. When it comes to association meetings, there are certain topics that absolutely do require advance notice to the owners in order for you to actually vote on them at the association meeting. So if your intent is to remove a board member from the board, if you're ratifying a budget or a special assessment, if you are revising your rules in a WUCIOA community, that requires advance notice to the owners. If you are trying to amend your CC&Rs, and in some cases your bylaws, those are all things where you do have to tell the owners ahead of time in your notice of the association meeting, look, hey, we're going to vote on this thing, and you have to tell them about it in advance. If you look at RCW 6490-445, subsection 1C, that is the WUCIOA provision about notice to owners in advance of an association meeting, including things like the timing of the notice and what information has to be included in the notice. And if you're not governed by WUCIOA, just Google your governing statute and then plus meetings or and meetings to find your specific statutes section on board and association meetings. So what I mean by that is, let's say you're a new act condo, you would Google RCW 6434 and meetings, and your first or second search results is going to be a direct link to the meetings section of your governing statute, and you can read through all of the limitations and the requirements. I think that covers the question. Tima, did you have anything you wanted to add there?
No.
No? Okay. All right. I'm going to keep going with one more question, and then I'm going to hand it back to you. I have a question for your Wednesday Q&A regarding RCW 6490-455 subsection 9, which is the section of WUCIOA that talks about secret ballots. The question says, I imagine that this applies only to condos and not to HOAs. Is that correct? Short answer, that is incorrect. This applies to every WUCIOA community. And on January 1st of 2028, it will apply to everybody because WUCIOA will be the only governing statute left. The question goes on to say, how can a vote be conducted in secret? The board would have to distribute the ballots and count them. Thereby, the members of the board would know who voted and how they voted. It would not be secret to them. Would the board be required to hire a separate entity to distribute and collect the ballots to maintain secrecy? I can see a number of nefarious actions a board could try to do. I'm going to start with that last sentence first and say that while we do understand that boards acting inappropriately is something that does happen on occasion, a lot of you might be surprised to know that when CAI National conducted a survey of thousands of homeowners who live in HOAs and condo associations, almost 90% of them were happy to live in a community association and were satisfied with the work that their board is doing on their behalf. And it might also be helpful to know that, you know, we're the ones that people call when stuff goes sideways, right? So when boards do really bad stuff, we are often the ones that get called. And for the most part, I would say the overwhelming majority of the time, the board members that we work with and that we hear about are trying really hard to do a good job for their association and are not trying to hide things from their community, act inappropriately, lie about what they're doing, take advantage of anybody, or profit personally in any way from their service on the board. So there are exceptions to that, but I think by and large, board members do their best to act in good faith and in the best interest of their community. I also want to point out that we did answer similar questions both on October 16th and October 30th. So if you go to our YouTube channel and look at the videos for both of those dates, you'll find more information about the secret ballot question. And I'm going to go back to what I said originally, which is that the only statute that mentions secret ballots is WUCIOA. So this answer is not relevant to any community unless it is governed by WUCIOA. at least for now. Starting January 1st, 2028, this will be relevant to everybody in Washington state. Under the statute, secret ballots only apply in 4 specific situations. There's nothing to stop a board from adopting a secret ballot requirement in the governing documents, but that would generally require a vote of the owners. And so that's something that you would have input on. And we've also advised clients to keep ballots secret under other legal principles at certain times. So the statute in question, again, is RCW 6490-455 subsection 9, which again is applicable now for WUCIOA communities, applicable to everybody on January 1 of 2028. And secret ballots for association votes are conducted when it comes to the election of board members, the removal of board members or officers, amendments to the declaration or governing documents, and approval to reallocate a common element to a limited common element. This is a very small subset of subjects here. Secret ballots are not required for budgets or special assessments or a wide variety of other votes that a community might take. Ultimately, the board is the governing body for the association, right? Not the manager. And so if the manager is an agent, could be the person who distributes and then collects the ballots and maintains the secrecy of the ballots, even from the board, if that is a decision made by the board to give that authority to the manager. We would expect that for self-managed associations, a small committee of volunteers, board members, owners, residents who are non-owners, whatever, or, tellers of the election, if you're familiar with that term, would be appointed for each election. They would be the ones to compile the results, but how each owner voted individually would not be disclosed. If you're concerned about trusting your board or any such committee, your community can certainly hire an independent third party to tabulate the results of an election or a secret ballot, but that does get expensive and impractical in a lot of situations, especially if you're a smaller self-managed community without a large budget, etc. I think where I would sort of take us back to is some of my very first comments on this question. It is, unless you have a reason to distrust your board, I would start from a position of trust. If your board has not given you a reason not to trust them, then I would not assume that you can't trust them with a secret balloting situation. Secret ballots have been handled by municipalities, small governments, large and small, and all kinds of different organizations for, dozens and dozens and dozens of years. So I don't think there's any reason that associations can't figure out how to mechanically make this work and to comply with the statute. And I also don't think there's anything inherently wrong with the board, for example, being the group that tallies the votes. And I think there is a situation where a board might choose not to be the one. So for example, if a particular board member is up for re-election, they might choose not to be on the committee counting the votes, for example, so that there is not an appearance of a conflict of interest in terms of their involvement there. So I think that's enough for now. And Tima, if you have anything to add on that subject, feel free.
Nope, I think you've covered it.
All right.
Okay, our next question is, can members of the HOA purchase a property in their own community after January of 2025? Before I provide my answer, I will preface this by saying we assume the question here relates to the WUCIOA restriction prohibiting board members from bidding on any unit being auctioned off to foreclose an association's lien. And the short answer to that question is that no board member, nor anyone closely connected to a board member, as defined by WUCIOA, can bid on a unit when an association is the one foreclosing on the unit. The association, the caveat to that is that the association can still bid as an entity, but not board members or their affiliates. This law applies currently in WUCIOA, and of course, after January 1, 2028, this will apply to all communities. So it's a relevant question. I think one of the follow-up anticipated questions that we saw here was if you're an LLC, would that be some type of exception? And our position on that is that most likely not, because the statute here that you'll want to refer to is RCW 6490 480 section 13E. And without reading it in full, I'll focus on the relevant parts there, but mainly it says that that no member of the association's board or their immediate family or affiliates are eligible to bid for purchase directly or indirectly any interest in a unit at a foreclosure of the association's lien. And, you know, then they go on to define immediate family members, spouses, children, etc. You know, so essentially the answer is no. Valerie, do you have anything else you wanted to add there?
Nope, I think you covered it. And again, as with any question, if we make an assumption about what it is we think that you're asking, we get it wrong, feel free to correct us in the comments. We're always happy to have you give us clarification. I'm going to move on to our next question. If a community manager records a board or association meeting for their own purposes, such as reviewing later for notes or action items, does this recording qualify as an association record that must be shared with homeowners? Or can it be considered a private record of the management company that is not subject to disclosure? So I think that generally, if a manager or a board secretary, for example, records a meeting to assist them personally in preparing the formal meeting minutes, as an example, I would treat that as a personal record, not as an association record. I would consider it to be something like a temporary set of notes, which would be destroyed after the formal minutes are prepared. And I also don't love the wording of the question that would treat any record as belonging to the management company, because the management company is acting as an agent of the association. The association's records belong to the association. So I think the wording of that just kind of felt a little bit inaccurate to me because of the agency relationship there between the association and the management company. I will also point out something that we have said repeatedly, which is the official record of what actions are taken at a board meeting are the board meeting minutes. That's the official record. And even if a recording does exist, that does not supplant or replace or override the board meeting minutes in terms of being the official record of what happened at that meeting. So I would say that in particular, if it is a recording that's kept to assist somebody, like a set of notes in putting the minutes together or identifying action items, and if it is destroyed relatively soon after the meeting, is over, for example, you keep it just long enough for the board meeting minutes to be approved at the next meeting, and then you destroy the recording because you no longer need it, because you've got an official approved set of minutes, then I think there's no requirement to consider that an official association record that has to be disclosed to your ownership, in particular if it's being destroyed at relatively frequent intervals. Tima, did you have anything you wanted to add?
I don't think so. No. Should we move on to our next question?
Yes,
the question here is the document entitled Reviewing Declarations and Bylaws for WUCIOA Compliance provided by Ken and Katie at the CA Day presentation very clearly lists things that we cannot do, that we must do, we might look for, and of course it's clearly labeled this is not legal advice. My question is, how can our HOA determine which of these provisions are currently applicable to us, even if we have not adopted yet WUCIOA? And if there are others, how do we find them? So essentially there's two options for a client. It's called the self-help option. The free option is you can go on the internet and you can research the statute and you can go through your governing documents line by line and do your own sort of Q&A and go through it step by step and try to figure it out on your own. You can, all of this information is available on the internet and you can spend that time doing so. The second option is to hire help and to get an attorney, hire an attorney to review your governing documents and do a side-by-side analysis of how your governing documents would be affected by the upcoming changes when WUCIOA goes into effect. We charge $1,250 for this, and we believe that's reasonable. And if you want, we find that we're attorneys and we still find this can be complicated. So if it's something that we find complicated, most likely someone who isn't an attorney is going to find it complicated. So we're not saying that's what you should do. We're just saying that you have two options, and those are the best two options we can clarify with you. I guess it would be important to say that as of now, very little about WUCIOA actually is affecting non-WUCIOA communities until January 1st, 2028. That being said, that time will come quickly and it's best to be prepared. Also, do remember that when WUCIOA does go into effect, you don't need to proactively change your governing documents because the statute is going to trump those inconsistencies regardless. That being said, it's best to know and to be prepared for what those changes are, and that will take place. Valerie, do you have anything to add?
Yeah, one thing that I'll point out is that if you do have your association attorney prepare such a memo for you, you can specify that you would like a memo that you can share with the ownership as opposed to one that is privileged communication between the client, the board, and the attorney. And in particular, if you're not going to redo your governing documents when WUCIOA for all takes effect, that might be a particularly useful tool for you to have, because I can envision a scenario, and I'm sure many of you can as well, where an owner is saying, but the documents say, fill in the blank, and the statute has overridden that provision of your documents. But you can say that to an owner until you're blue in the face, and they may not believe you. But if you have a memo from the association's law firm pointing out when the statute takes effect, the inconsistent provisions, what things you have to do or can't do once WUCIOA for all takes effect, and you're able to provide that to your ownership as well. For some owners, that might be more persuasive and they might be more inclined to believe that you're not just trying to pull the wool over their eyes and ignore this provision of your documents. So I think that memo can be a very helpful tool, not just for the board and the management company in terms of how do we govern once WUCIOA takes effect for everybody, but can also be a good communication tool and kind of get some of your owners that might be upset about some of these things to simmer down a little bit. That is the end of the questions that were submitted to us in advance. So I'm going to go ahead and start reading the questions that were sent to us in the chat. And Tima, I'm just going to go ahead and say that you get first crack at any of these where you want it. And if you need my input or just don't want to take a question, you can let me know. So the first one is this. On the beneficial owner information report, do you recommend requesting a FinCen ID number for the reporting company?
Well, my understanding of the requirement is that you don't need to do that, and that all you need to do is provide information that frankly the Treasury already has, but I may be misinterpreting the question, so I'll pass it back to you, Valerie.
Well, I think this question is specific to the reporting company question, and I think in that scenario that it might actually be a good idea to request a FinCen ID number for the reporting company. So this is a scenario where maybe your management company is filing the report for your community, or maybe you found a vendor that's doing CTA reports for community associations and you're paying a third-party vendor to do it for you. There is a section on the beneficial owner information report, which is the actual thing that you have to file for your community, that requires the person who's filling it out to tell the government who it is that's filling out the report, right? So I had to, when I filed the BOIR for our law firm, there was a little section that required me to fill in my information and say that I was a partner in the firm when I was filling out the BOIR. So if you have an independent third-party company that's doing the report for you, they are going to have to identify themselves in the BOIR as the reporting company, and it probably makes sense for them to have their own FinCen ID number. They may not be required to, and if a board member or an individual is doing the filing for you, then that might be unnecessary. Although if it's a board member, they should have their FinCen ID number anyway. So whole separate question. All right, next one. In regards to board meeting minutes, is it necessary for them to be signed? Or if it says submitted by and then the typed name of the secretary, is that good enough?
I don't believe that they are required to be signed. I don't have any authority to say that that's correct. You're welcome to sign them, but I don't think that that's a requirement. Valerie, do you disagree?
I do not disagree. I think you are correct. They do not have to be signed. In fact, trying to think about, I think maybe, I don't even know if 10% of the board meeting minutes that I've seen in the years that I've been in this practice are actually signed by the secretary. I think the most important thing for board meeting minutes generally is that they clearly identify, the date of the meeting, the board members in attendance, the action items that occurred, meaning, this motion was made, this vote was taken, this is the thing that was decided by the board. And I think identifying who's taking the minutes is a good idea, but I don't think a signature is required. All right, next question. If board members are refusing to provide their FinCen ID numbers for the CTA filing, can the board file without providing the non-compliant board members' ID numbers, or can the filing only be completed if we have ID numbers for all board members? Do you want me to take this one, Tima?
Yeah, I mean, I think this sort of relates back to the first question, but that you could hire a third party to do so, but I'm going to pass this back to you, Valerie.
Yeah, so I think I'm kind of turning into our resident CTA expert in the firm, so that's why I volunteered. The reporting requirements for the beneficial owner information report give you two options if you're actually going to comply with the CTA. Either you have to, as a board, have the personal identification information for each beneficial owner, or each beneficial owner has to get a FinCen ID number themselves, give it to you so you can then file the BOIR for your association. You have to have one or the other, otherwise you are not complying with the CTA's reporting requirements. So if you have a board member who is refusing to give you a FinCen ID number for them, or who is refusing to give you all the information you otherwise need to file the BOIR, which would include their name, their address, I think their social security number, and a copy of a government issued ID like a driver's license or a passport, you can't file a report that complies with the CTA without either the FinCen ID number or that personal information. And in my universe, I mean, I think every association should have their board members go out and get their own FinCen ID numbers, because then board member privacy is protected because board members aren't being forced to turn over their personal identification information to their association. But also the association is not also storing private identification information for its beneficial owners. And I do want to, just as an aside, remind everybody that beneficial owners is not just board members. It's anybody who has significant influence over the corporation, including anyone that owns 25% of the shares within the community. So if you happen to have an owner within your community that owns 25% or more of the allocated interest in the community, they are a beneficial owner even if they're not on the board. So that's just something to keep in mind. Next question. If a homeowner is in violation of exceeding the 72-hour parking limit on the street per the CC&Rs and they move the vehicle slightly each time to avoid enforcement, what steps can the HOA take to contain the situation effectively? I think I'm just going to preemptively say this is too specific and requires legal advice, and so it's not something that we can answer in the context of this Q&A. So I would send that question to your association attorney. There was another question in the chat that said, would that include board members that are acting out of line? I don't know what that is in relationship to. So if you are the person who submitted this question in the chat, can you please come back to the chat and give us some context about what this was a follow-up to so we can answer it? And in the meantime, I'll go ahead and move on to the next question in the chat. Bylaws allow the board to have a special meeting with 3 days notice to the board. Does this meeting need to be open? And do owners need to also receive the 3-day notice? Do you want to take this one, Tima?
I'm not sure I know the answer to that. I'm gonna let you answer that, Valerie.
Okay. It depends on whether your community is required to hold open meetings. If you are an open meeting community, then you're governed by the open meeting requirements in your governing statute, which would be either the HOA Act, RCW 6438, or WUCIOA, RCW 6490. Those both have notice requirements. In particular, for example, WUCIOA requires 14 days notice of board meetings to the owners. And WUCIOA has a very, 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 very small and specific exception to that notice requirement when there's an emergency that qualifies under the statute. But it's very narrow and almost never applies to what your situation is. If you're in a community that does not have an open meeting requirement, the notice of board meetings does not necessarily need to be given to your owners if you're not holding open meetings. So I think it depends on what type of community you are, whether you have an open meeting notice requirement, an open meeting requirement in terms of the amount of notice that you have to send to your ownership, if any, of such a 3-day notice board meeting. So I think that covers that. We had the clarification that I asked for came into the chat here. When a homeowner is speaking out of turn or being disruptive, they may be removed from a meeting. Does that apply to a board member as well? That's a great question.
Well, I guess my first thought, and based on the fact that, you know, just from a reasonable standpoint, I don't see why not. A board member is still a member of participating in the meeting. And if they're being disruptive, that falls into the description that is being made there. You know, I guess it would depend on exactly what the behavior was and what you describe as disruptive. But, you know, based on what you're saying, I don't see why a board member would be excluded from that. Valerie, do you have any other thoughts?
Yeah, you know, that's a really interesting question. And I think it probably depends on a lot of different factors. I don't think that the statutory provision that allows the board chair or the meeting chair to eject a disruptive homeowner from the meeting necessarily applies to a board member. So I don't know that I would go that far. But I definitely think there is a scenario in which a board member becomes so disruptive that the board as a whole cannot conduct an effective, efficient meeting. And I also see that this could create other concerns. Like, what if you have what if you have 3 board members? What if you have 5 board members? And there are 3 in attendance at a meeting, and one of those 3 is being disruptive. If you want to kick them out, then all of a sudden you don't have quorum, right? So I think you have to be careful about removing board members from meetings. I think it probably depends on the level of disruption that they're creating in the meeting. I think that at a minimum, if it gets bad enough, you can certainly, as a board, decide to adjourn the meeting and just say, we cannot operate effectively as a board because this person is being combative. Maybe they're intoxicated. Maybe there's a lot of different scenarios that could happen, right? So I think that even if you're not able to safely remove the board member and then continue to conduct business, adjourning the meeting is always an option if the behavior rises to that level. And I would also say that if you're dealing with that in a community that you work with or in your particular community, you should absolutely be consulting with your association attorney about options and sort of like a game plan generally to handle that type of disruption, because usually that is not a one-off thing. Usually people who are disruptive to that level are not just doing it at one meeting and then showing up and being perfect angels at the next meeting. So that's something to talk with your association attorney about, to have sort of a larger plan to manage that situation. Okay, next question. Under 64, it says 6334. I think this means 6434. There are requirements for reserve accounts, reserve studies, budgets, and assessments. I could not find where the reserve accounts must be funded per the reserve studies, budgets, and assessments. Does this mean in cases where operating expenses are high for the month, the contribution to the reserves can be less than budgeted? Does the reserve shortfall have to be made up later? You want to take a stab at this one, or you want me to run with it?
Well, I'm trying to figure out if this is is this a question about the budget? Are we trying to determine if the budget is am I
No.
understanding the question?
No, I think the question is, we've budgeted for X number of dollars to be contributed to the reserve account, consistent with our reserve study.
Okay.
But this month, insurance costs hit all at once, and we don't have enough money to contribute that money to the reserves. Is that okay? And if we don't make that contribution, do we have to make it up later? That's how I interpret it.
Okay. Well, I guess my first answer is if you can't make the contribution, you can't make the contribution. And that's just a fact. As to whether or not it needs to be made up later, I don't know the answer to that question. So I'll let you handle that.
Sure. I will remind everybody that a budget is not a prediction of the future. It is a
Snapshot.
It's our best guess about what the association's expenses and income are going to look like for the next 12 months. And in real life, just like I might have a household budget that says I get to spend, my mortgage is $2,300 and my food bill is $1,000 and my gas is $175. But if I have to do a lot of driving that month and my gas bill is $250, there's no lightning bolt that's going to come out of the sky and strike me if I spend more than my budgeted amount on my gas that month, because circumstances on the ground dictate sometimes varying from the budget. So a budget is a planning tool, but it is not set in stone, and it is very normal for actual expenses to vary, sometimes in minor ways and other times in major ways from the budget, which again is a planning tool. Also, under the Condominium Act, which is the statute that this question is about, while there is a requirement to have a reserve study and to establish a reserve account, there is no requirement to fund that reserve account in a particular manner. That being said, when you tell your owners how you are going to contribute to your reserves, which you disclose as part of the budget ratification process, if you are then during the year unable to fund the reserves as planned, I think it's appropriate to notify the owners. If you have unexpected expenses, let's say there's oh man, we just had this huge windstorm a few weeks ago, right? We've got some of our communities that are dealing with tens of thousands of dollars in expenses for downed trees and water runoff issues and fences that were destroyed or whatever. So if you're dealing with those kinds of expenses and you are diverting money from your operating budget to pay for these unexpected expenses, send out a notification to your owners that says, we had budgeted to contribute $15,000 per month to the reserve account this year. Because of the windstorm, those funds are being diverted to pay for X, Y, and Z, and therefore we will not be making those contributions for, November, December, and January. You don't necessarily have to make up for it later, but I think the principle that I am standing on when I say tell your owners this stuff is that disclosure is clearly what is favored by the legislature, which is why they have this list of required disclosures to be made to owners in the budget ratification process. And disclosure to your owners is about transparency and governance within your community. So I think if you can't make the contribution to the reserves, you can't make the contribution to the reserves, and you should just disclose that to your owners, explain why. And if it's reasonable, sure, come up with a plan to make up for the difference if you can within your community. All right, next question. Are all condos required to have an audit if their assessments exceed $50,000? Or is that something that will be effective in 2028? I'm going to look this up really quickly because this depends on your governing statute. So, for example, if you are governed by 6434, which is the Condominium Act, if you look at 6434-372, it says the financial statements of condominiums consisting of 50 or more units shall be audited at least annually by a certified public accountant. In the case of a condominium consisting of fewer than 50 units, an annual audit is also required, but may be waived annually by unit owners other than the declarant of units to which 60% of the votes are allocated. So in other words, if you have 50 units or more, you have to have an audit, period. If you have fewer than 50 units, you have to have an audit. But if 60% of your ownership votes to waive it, you can skip it. That vote has to happen every year. That's not something that you just once and forever, you waive the audit, okay? You're talking about the 6490 or WUCIOA provision on audits. And what that statute is 6490-530. And it says that the financial statements of associations with annual assessments of $50,000 or more must be audited at least annually by a CPA. In the case of an association with annual assessments of less than $50,000, an annual audit is also required but may be waived annually. Again, this vote has to happen every year by unit owners other than the declarant of units to which a majority of the votes in the association are allocated. So under WUCIOA, you can waive the audit requirement if your assessments are less than $50,000 a year and if a majority of the voting power in the association votes to waive that audit requirement. So I think that answers the question. If you have follow-up questions, you can send them to the info@condolaw.net email address. All right, next question. We understand that no proxies are allowed for a budget ratification, but we were challenged on that point in a meeting last night. Can you let us know where that is stated, or are we incorrect on that point?
I think we addressed this a couple of sessions ago, but regardless, you're asking for that. So the question is why?
Are proxies allowed for budget ratification meetings?
I do not believe so.
I'm going to disagree with you on that. Proxies are not required for a budget ratification meeting. But if somebody shows up to the budget ratification meeting with a proxy that is executed in a manner that is consistent with the rules in your statute, then I think you have to allow it.
Oh, that's right. We were discussing board meetings and we were discussing the difference between that and budget ratification meetings. So,
right.
Correct. Okay.
So I think that an association is not required to provide proxies or even ballots in advance of a budget ratification meeting. But if an owner shows up to a budget ratification meeting and they've collected a proxy from their neighbor, and you can reasonably verify that the person who purports to have given the proxy is the one who gave the proxy, because there is now a sort of a verification requirement under the statute, under WUCIOA anyways, then you have to allow that proxy. So I think that's the short answer to that question. Don't have to provide it, but you have to allow it if it's consistent with the statute. Next question. We have a lot of questions in the chat today. You guys are coming through. Thank you. One owner owns 2 commercial units. They are selling the commercial units together. Management was previously advised to require a separate resale certificate for each unit. The owner is forcefully requesting one resale certificate with both units listed so they can save money on the purchase. Can 2 units be combined on one resale certificate?
I've never heard of such a thing, and I cannot recommend that to a client that they do so. They're 2 separate properties and they have different tax IDs, and I can see no exception to that unless Valerie, you can think of one.
Nope, I think you are, I agree with you entirely. I do not think you should combine 2 units on one resale certificate. That being said, I do think that there is obviously significant overlap in the work required to prepare what will probably be 2 nearly identical resale certificates. So maybe one way to get the owner to settle down about this is to offer a discount on the combined cost of the 2 resale certificates. Because while the statute allows a maximum charge for a resale certificate, that is not a minimum charge, it's not a requirement. And again, because you're going to be producing 2 nearly identical documents with very few differences between them, I think it would be very reasonable for the association to offer a discount to the seller in producing those 2 resale certificates. All right, next question. If a board uses funds that would go to the reserve account contribution for something else, do they still need to pay it back within the 2-year expectation? Do you want to take this one, or do you know the answer?
Well, I would just say, I don't know. Again, I would go back to what we discussed earlier, which is if you're not using funds for the reserve account that you're supposed to, I would go back to what Valerie said about transparency and communicating that to the ownership. I'll let you answer the second part of that.
Yeah. So I think I'm not entirely clear on the circumstances here. If a board uses funds that would go to the reserve account contribution for something else, do they still need to pay it back within the 2-year usual expectation? The way the question is worded suggests to me that you are diverting money from your budget, and instead of it being contributed to the reserve account, you're using it for something else. If that is the correct scenario, then I think the answer to the question a few minutes ago applies, and I think you notify your ownership, but there is probably no obligation to pay it back. The obligation to pay reserve account funds back is when you borrow money from the reserves out of schedule with your reserve study, right? Or for a non-reserve component. So let's say, I don't know, you have some big litigation going on and you have to pay an expert, of some kind of expert to testify in your litigation, and there's a $50,000 price tag for that. That's not something that would ordinarily be paid out of the reserve account. And if you borrow $50,000 from your reserve account to pay for that non-reserve expense, under the statutes, you have to notify the ownership of that. And unless it represents an undue hardship for the association, you have to have a plan to repay that money into the reserve account within 2 years. I don't think that's the scenario that you're asking about because of the wording of your question. You can feel free to clarify, but I think I sort of answered it both ways in those comments. So I think that's probably good enough. All right, next question. We have an owner who is requesting to review the invoices of the association. And the question is, how much financial documents should be shared with owners?
When this happens, we occasionally have owners request to review invoices. And when it comes to financial information, that's different from what we do, which is called redacting privileged information that is contained in the invoices. The financial information is not in and of itself privileged. It's the actual, when we draft our invoices, they have certain specific information in there that may or may not be required to be disclosed, and therefore we redact those. Unless Valerie has something to add here, I don't believe that the actual amounts disclosed, that there's anything privileged about that specifically.
So I think this is a broader question than just about the legal fee invoices. So I think your comments about how to disclose legal fee invoices are correct. In other words, if an owner requests to review invoices, it may be appropriate to redact attorney-client privileged information before disclosing them. But I think the larger question here is how much financial information of the association generally should be shared with your ownership. And the answer is that owners in a community association have the right to review association records, including financials, in the manner in which they are kept in the ordinary course of business. And so if they want to see copies of your landscaping invoices or your management invoices or even your legal fee invoices, they're entitled to review those. And unless there's an improper purpose, which is almost nearly never the case. Not to say that owners never have an improper purpose, but it's hard to prove that to the point where you can refuse to allow them to review financials. So if they're asking for things like the balance sheets, your profit and loss statement, copies of the bank statements, all of that stuff, they get to review all of that stuff. You do have an obligation to comply with the records statutes in redacting certain types of information from any records that you give to your owners. So if you have questions about specifics here, Google your governing statute plus the word records. So RCW 6438 and records. And that will take you to the section of your governing statute that has a whole section on records, what you have to keep, how long you have to keep them, owner right to review them, your obligations or lack thereof to compile records in a certain way if an owner demands it. You don't have to synthesize or compile them in a specific way just because an owner asks for it. And it will also talk about the type of information you have to redact from the records before disclosing them to the ownership at large.
There's a very specific list.
Yes, there is. And I think that takes us right up. Look at that. It's exactly 11 o'clock. So there was one very long question that we didn't get to in the chat today. I'll put it on our list for next week and we'll cover it if we can. Thank you all so much for joining us, and we will see you back here next week. Bye, everybody.
Bye.